Hello, welcome back, everyone. Hopefully nobody, my understanding there was some hail in parts of town, so hopefully everyone is okay. The key, I guess, is to protect your vehicle. All right, so we're just waiting for Mr. Toshi. We're waiting for your client to zoom in.
Okay, well, he's at the jail, so I guess we're waiting on them. Did you say it
Yes.
was hailing?
Yes.
Oh, I didn't hear that.
Is my accent getting in the way?
No, well, I thought you said hail, but it's kind of clear down here, so I was surprised to hear that.
No, it was. And it's funny, some people don't use their garages for vehicles. They use them for other things. So I have people who are always like, can we borrow your driveway so your tree will sort of protect? I'm like, yes, you may borrow the driveway. And then, of course, when you have teenagers, they're all driving. So a garage can only be so big. All right, Luis Martinez, your client, is all the paperwork done?
Not quite yet. We're still working on that, but he needs to get on, Judge. He was on yesterday, so he should know how to do this.
Well, sometimes memories fade.
Oh,
Even from day to
sometimes
day.
it's a lot to ask somebody to get it right 2 days in a row, right, Judge?
It is.
Now, to your earlier point, on more than one occasion, my wife has run me outside to put her car into the garage. Of course, that requires me going and moving like 4 or 5 things over to the other side of the garage and putting it in.
Oh my gosh.
But that's what we do. That's what we do.
It's funny. My neighbors will tell me, your garage is not supposed to smell like roses because I put plugins in the garage because I'm like, I want it to smell nice. The smell of gasoline in a garage just doesn't, it's like,
Jim,
Oh.
I put us in a breakout room because I was going to talk to you about this case other than the bond issue.
Okay,
and is someone here from family violence? I know you all probably may not be here because I don't think you have anyone on the docket.
I'm here, Judge.
Joe Ray, it shows that you all have an agreement with Mr. Keesee, Keesee. The cause number is NIMAG 628-439. And it's a request for him to have contact with the child. And I just want to see, we may need to have a short hearing on that because I want to see what Child Protective Services is saying.
Okay. Yeah, I'm in the email chain with Defense and Michelle.
And I looked in that, unless I missed it, I don't see where there's any person-to-person contact with the Child Protective Services worker. But I don't think we're supposed to have any rain today. So I don't know where that came from.
It was so random.
Mhm. That's what everybody was saying. Was it sort of like a Wizard of Oz, where the house twitches and twitch, and then you're in the land of Oz? Because I saw later this afternoon, everyone was on Facebook posting about the hail.
Big Judge, on that one, I just have notes from intake that said there's no open CPS case in our office.
Okay, and see, I'm wondering what's going on because in his motion, and I think we'll have a slight hearing on it. In his motion, it says that they're working with Child Protective Services. So I don't know if it was a legal case or not.
There may be something with the other kids, but I'm not sure.
Okay, all right, Ms. Ferguson, can you set this on the docket? I'll put the cause number in the chat box, and it's just for a bond issue.
I have the motion with me, Judge. We gave it to me
Yes.
yesterday. I have the case number. Thank you.
All right, thanks.
Do you want me to set it for next week?
Well, the state is in agreement with it. I just have some concerns. So if we could perhaps set it to give whoever the CPS worker is a chance to come in. So next week probably would do it.
Okay.
And Joe Ray, if you know who that CPS worker is, if they could perhaps come, that would be great.
Okay, I'll reach out to him. I know who it is.
All right, thank you.
Judge, can I see in a breakout room?
Yes. You want to go to breakout room number 1?
Sure.
All right, and Mr. Toshi, we're still just waiting for them to bring your client.
Okay.
James Toshi. All right, Mr. Villarreal, we're waiting for your attorney.
Sorry, Judge.
Oh, no problem. They just brought your client in.
Okay.
All right, so are you ready?
Yes, ma'am.
All right, and Ms. McIntyre?
Yes, Judge.
Are you ready?
Yes.
All right, and to the clerks, do you have the motion on Villarreal, please? And is that motion on both of these cause numbers?
It should only be on the one, Judge, the assault public servant. He has a bond on the other cause.
Okay.
I'll
All
pull it
right,
up,
so
Judge.
we'll proceed while the clerks get the motion for me. So just one moment. All right, the court is going to call 2021 CR 10285, State of Texas versus Christopher Villarreal. Can I have parties announced for the record for the state,
Meredith McIntyre for the state.
for the defense?
James Tochi for Mr. Villarreal, Judge.
And are you Mr. Villarreal?
Yes, ma'am.
All right, we're proceeding with this hearing by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, ma'am.
All right, Mr. Villarreal, do you have any objections to this hearing taking place by video?
No, ma'am.
All right, the court is in a receipt of a motion to set bond filed by the defense. State, have you had a chance to review the motion?
Your Honor, I haven't, but I am familiar with the contents though.
All right, are you ready to proceed, State?
Yes, I am.
All right, defense, it's your motion. You may begin.
Judge, I was really going to make a proffer. I don't mind calling Mr. Villarreal if you would prefer that, but basically I am requesting that the court set bond in regard to the motion that was filed. He was on bond earlier, and apparently his bondsman filed an affidavit to surrender him, which triggered the warrant and the remand by the court. And so I believe that he is entitled to a bond, and his previous bond was set at 20,000. I'm asking the court to either set it at 20,000, or if somehow the court might consider a lower bond, of course, we would be amenable to that. But that's basically it. I'm just asking the court to grant him a bond on this case. I don't believe that a violation report has been submitted triggering the warrant. The warrant was triggered by the court because the bondsman got off the bond.
All right, and Mr. Toshi, why did the bondsman ask to be withdrawn from the bond?
I've not been provided a copy of the affidavit, Judge. It should be in the court file for sure, and so, but I was not provided a copy of it.
It's not in the court's file, but we will discover that.
It should, well, it should be there.
No, it's not.
Huh. Well, it's listed in the details of the incident details on the case, so I know it was an off bond.
All right, to the clerks, can you see if you have the affidavit of surrender surety under this cause number for Mr. Villarreal?
Yeah, I'm pulling it right now, Judge. It's not in the file because it was filed when it was a NIMAG. That's why.
All right, thank you,
I'm pulling
Robert.
it. Uh-huh.
And for the record, that's our clerk, Robert. All right, is there anything else, Mr. Toshi?
No, ma'am. I'm just asking that you set a reasonable bond, Judge, and that's pretty much it.
All right, the clerk has brought the court a copy of the affidavit of surety to surrender. Is there any objections to the court reviewing that from the state or the defense?
No, Your Honor.
No, there's no objections, Judge.
All right, so the reason that they put in this motion for why they wanted off the bond in this cause number is because that he was at the Bexar County Jail on other non-related charges. So that's why they, just so everyone will know, that's why the bondsman is stating they want it off the bond. So once someone wants it, does anyone want to address?
Judge, I mean, if you want the state to speak, I mean, I don't know if Mr. Toshi is done, but I do have some exhibits to offer, and one of my exhibits addresses that issue, I believe.
Mr. Toshi, is there anything else from the defense?
I mean, no, Judge. I just know that the court is very familiar with this practice. It's not an uncommon practice for a bondsman to go off bond when they find one of their clients is in jail. So, no, other than that, Judge, I have nothing else. And of course, I have no objections to you receiving the state's their exhibits. I've received them and reviewed them as well.
All right.
Yeah, Judge, Your Honor, I have emailed Your Honor as well as the court reporter, Mr. Tochi, 3 exhibits, states 1, 2, and 3, offense reports, as well as the criminal history. So the state is at this time.
All right, and any objections, defense to states exhibits 1, 2, and 3?
No, ma'am. No, ma'am.
All right, so states exhibits 1, 2, and 3 are admitted. And for the record, the court had received states exhibits 1, 2, and 3 by email, and it includes the court reporter. The court does not review any exhibits that are presented through email until they are accepted into evidence. All right, state.
Yes, Your Honor. So in those exhibits, you'll see the offense report for the current offense that defense is asking for a bond to be set, as well as an offense report for a subsequent offense from September, and then the criminal history. And in terms of the timeline of events, you can see in the criminal history that on, well, let me get the date right here. On June 26th of 2021, this defendant was arrested for an assault family violence second offense. That case has subsequently been dismissed for some evidentiary issues, but the affidavit from the bondsman was then filed beginning of July. So it was because of that offense, just to give the court some clarity on that. But as far as setting a bond amount, we're going to ask that his bond first definitely not be lowered, because he's been out on felony bond and has since picked up a new offense. I understand one of them was dismissed, but we do have a new one in September. We also have his criminal history, which Your Honor can see includes 2 prior trips to prison. He is a habitual offender. He is also a gang member. For the safety of the community, that we do not need a bond that's lower. We're asking for higher. We're asking for $25,000. Obviously, it's within the discretion of the court, but at this point, definitely oppose a lower bond than what was originally set, which was $20,000.
And everyone, just give me a moment while I review the states exhibits 1, 2, and 3, please.
Judge, may I speak on my behalf, or do I gotta be quiet?
No, you can speak on your behalf if you so wish.
Yes, ma'am. I understand my prior history, was in
Well,
the
let me
past.
have you raise your right hand for me, please. Do solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right, you can lower your hand and state your name for the record, please.
Christopher Villarreal.
All right, Mr. Toshi, it appears that your client wishes to speak on his behalf regarding his criminal history. Would you like to ask him some questions?
Well, I'll just ask him this. Christopher, what is it you would like Judge Boyd to know before she decides what bond amount to set?
As far as like my prior my history, I understand I made mistakes. Everybody deserves a second chance. Obviously it's a continued cycle. I don't make excuses for what I've done. I just ask for an open mind, to allow me to fix that mistakes. It really not what the judge should know, but it just I don't have no excuse for what I do or what I've done. I take full responsibility for what I've done. All I ask is, a little bit of leniency, my baby mother is I got a kid due in June. She's diabetic, got real seizures. I got a job out there, you know, so making bond, you know what I mean, can help if 20,000 or stuff like
Okay,
that.
Mr. Villarreal, let's start by saying the mother of my child.
Christina
That
Rodriguez.
seems, no. When you refer to someone, let's stop saying baby mama.
Yes, ma'am.
It seems more respectful to me to say the mother of my child or
Yes,
the
ma'am.
mother of my future child.
Yes, ma'am.
But go forth.
But I was basically her provider. I was the one taking her to doctor appointments. I was the one to make sure she's taking medication. Right now, she's living with my mother, and to me, as a man, I should be out there taking care of my responsibilities and taking care of her. And just because of my continual mistakes and yet to learn from them, is preventing me from being out there. And she's right now she's on SSI check, so she only gets so much money for the housing for her. So she, you know, she's the only one that is helping me out right now. Uh, if I, if you could grant the 20,000, I can, you know, a couple of months from now, I could probably bond out with her help. This will be the last time you see me. I have no problem getting a job. You know, I'm trying to enroll in Quest College again and try to get my CDL and my HVAC license. I understand my record, you know, really contradicts of what I'm saying right now. But all I ask is for a second chance to fix my mistakes. That's it,
Right.
ma'am.
Any more questions, Mr. Choshi?
Judge, I do not have any other questions.
All right, Ms. McIntyre?
Your Honor, state doesn't have questions.
All right then. Any further argument from the state?
Your Honor, I'll keep it very brief. The main issue here is not just the record from the past. The issue is what you do while you're out on bond for the current offense. And that is included in the exhibits we've attached. And so that is part of our concern and why we're asking definitely not for the bond that you set to be lower than the original amount.
All right, and who was the complainant on the assault case that was dismissed?
I have a name. Let's see. Angela De Leon. Is the name
And
I
is
have.
that the mother of your child, Mr. Villarreal?
No, ma'am.
All right, Mr. Tochi, it's your motion. I'll give you final argument.
Judge, I just wanted to add, I know that when these cases come in, that the judge or the magistrate, whoever it might be, that is going to set the bond, they review the facts of the case, they review, the criminal history, and they have all these tools and information before him or her at the time they set the bond. I do not believe they set an inappropriate bond at $20,000. The bondsman justifiably got off the bond because he was now in custody. I don't see any reason to increase the bond, and I don't think the magistrate that set it got it wrong. I feel the bond was set in an appropriate amount. I'm just asking you to set that bond back at the appropriate amount so he may have an opportunity to get out work and support his newborn child. Don't know what's going to happen with the case. That remains to be seen. But for now, trying to get somebody out of jail, I think is a good thing, if we can.
All right. And where is he planning on staying if he's released?
With my mother.
State, do you have any objections if he makes bond to him staying with his mother and the mother of his child? I mean, because the court is going to set a bond.
Right. No, they're not. Those two individuals are not the named complainants in the cases. So no.
All right. Mr. Villarreal, what is the
Yeah.
name of the mother of your child?
Christina Rodriguez.
And I've seen your history. Has Christina Rodriguez State, to your knowledge, been the complainant in any of his prior history?
That's what I'm looking at right now, Judge. It does not appear to be.
Right. Mr. Villarreal, have you ever had any alleged instances involving Christina Rodriguez?
No, ma'am. She's the only reason why I stayed out for so long and been at the house and trying to get a job.
Okay, I'm sure Mr. Villarreal, your attorney probably just wants you to answer the question that I'm asking and not veer off the answer.
Yes,
So my
ma'am.
question is just, are there any alleged criminal cases or police reports that have been filed involving Christina Rodriguez
No, ma'am.
with you?
No, ma'am.
And Mr. Toshi, is that correct?
Judge, I don't have access to all his files, and none have been provided to me in discovery, but I believe it is. I mean, I believe what he's telling you right now.
State, do you have anything that suggests otherwise?
Judge, I don't. In State's Exhibit 1, for the current offense, the reason they were called out was for a domestic issue, but the only, just so the court is aware, she was listed as a Jane Doe. So I do not know who that individual is. And there were some issues with that, so they did not proceed with that particular case.
All right, since we are live, I don't want it said on Zoom, but Mr. Toshi, I'm going to send you to a breakout room. And if you can discover for me the address where your client will be staying, and then we can see if that address is related to wherever this alleged incident happened. Because if there was an incident involving Christina Rodriguez, I'm not going to let him have contact with her until, you receive information and the states receive information that she wants to have contact with him.
Okay.
All right, so I'll send you both to breakout room number 1, if you can get that information from us in there, and then if you could share that information with Ms. McIntyre, and we'll go from there.
Okay.
So Mr. Villarreal, if you can go to breakout room number 1, please.
Yes, ma'am.
Sorry about that, everyone. I had to take my allergy medicine. So, Mr. Toshi, were you able to give that information to Ms. McIntyre?
Yes, Judge. I got the address of where Christina lives and also where he'll be staying. And I'll let Ms. McIntyre address it. I don't believe there's any connection between that address and the address in any report.
Okay. And Ms. McIntyre, please let me know when you have the information for that, if it's in any way related.
I do have the address. I've been given the address. I am not aware that it's related to anything. It is possible that there was an incident with Christina a long time ago, but not the recent ones, just to let the court know. I'm looking way back to the original misdemeanors. I think she might have been one of the ones, but not the ones from this year that they were called out for.
Okay, so Mr. Villarreal,
Yes, ma'am.
has Christina Rodriguez ever been a complainant?
No, ma'am. We got in just an argument and that's it. It was just a verbal, that's it, ma'am.
All right, is there anything else before the court makes its ruling?
No, Your Honor.
Not for me, Judge.
All right, then this is what the court is going to do. The court is going to set your bond at $20,000. There's going to be a GPS. Ms. McIntyre, is the state requesting full or partial GPS?
At this point, we would request partial with proof of employment to and from work only with curfew.
All right, this is what the court will do then. The court will add as condition partial GPS. The court will waive the fees. You'll be allowed to work upon proof of employment and a work schedule. And where is Ms. Rodriguez's family? Why is she living with your mother instead of her family?
Well, right now, as far as her family, ma'am, I really don't know the status. They always get in arguments and they always kicking her out. So right now she's staying with my mother and going through this Hearing for Hope program for the housing.
Okay. All right. So proof of employment and work schedule. And I'm going to set a curfew. State, what time are you asking for? In defense, what time will you be asking for?
I would say 7 p.m.
I like midnight, Judge, so he can go to dinner and maybe watch a movie or something like that.
Well, what I've learned, and again, my statistics professor will not approve of me doing this because I haven't run the numbers correctly, but I've discovered that nothing good happens at midnight. Absolutely nothing good. That's when all the trouble starts, midnight. If you're at home, as our parents always said, Brenna, come home before the street lights come on. If you're at home before the street lights come on, usually everything's great. The worst thing that can happen, you're at home and you burn the popcorn. Because when I was growing up, you didn't have the microwave to put the popcorn in. You had to put it in the skillet, put the oil, and there you go. So we're going to do 7 p.m. curfew. And if your employment ends up being different, Mr. Villarreal, your attorney can come back.
Yes, ma'am.
Ms. Ferguson, can I get a 30-day reset on Mr. Villarreal, please?
And Judge, before we Before you excuse myself and Mr. Villarreal, I'd like to go to a breakout room to have dialogue with him, please.
Yes.
Or after you.
Just make sure that he comes back because we
Okay.
have to excuse him from here. So we're going to come back on February 17th. And Mr. Villarreal, if you are on bond at that time, you need to make sure that you're available by Zoom on February 17th at 9 a.m. Do you understand?
Yes, ma'am.
So when is your next court date?
February 18th, 17th.
See, he's a jokester.
I'm sorry.
That's when people get in trouble.
No, I'm
it's
sorry.
not cute to be a jokester after you get out of kindergarten. All right.
Yes, ma'am.
Okay, so we'll see you at that time. Mr. Toshi, if you'll go to breakout room number 3,
Thank you.
and I'll send Mr. Villarreal to number 3.
And I'll send him back.
Thank you. Yes, you need to go to number 3, Mr. Villarreal. Ms. Ferguson, if you can get a deputy to help Mr. Villarreal go to breakout room number 3, please.
Yes, ma'am.
Thank you.
Excuse me, boss. Yeah. They're telling me to go to break 3.
All right, Norma, Mr. Villarreal can go back. He's 14C.
Yes, ma'am.
Hey, Robert, are you there? Or Lupe?
Yeah, I'm here.
Hey,
Yes, sir.
can you check on the paperwork for Cervantes?
Cervantes, yes.
Is there stuff missing still?
Let me check.
What I can tell you is I haven't received any. So it may be with the clerks.
No, I have not received no paperwork.
Okay.
And
Louis, where's your client at?
He's not on the Zoom screen.
Judge.
Yes.
Mr. Cervantes, he was having trouble with his audio, so I had him log out. He's trying to log back in.
Okay. So once he's logged back in, what I'll do is I'll put you in a breakout room with the clerks and we'll find out where the paperwork is.
Okay, well, he's doing that right now. So I explained to him what was going on. He was giving me the thumbs up. I told him, like, just jump off, sign all the paperwork, and then log back in.
Okay. All right. Thank you.
So we're all trying here.
All right. Oh, no problem. Everybody has some patience in their pocket. That's good.
Judge, I've learned the key to patience is if we had a better way of doing it, we would have done it the better way.
Hey, there you go.
Angela is.
Hello. So what I'll do, Louis, I'll send you and your client to a breakout room so we can see where the paperwork is.
Okay, Judge, he just finished it right now. I just helped him with it.
Ah,
He was
awesome.
down the street from my office, so he showed up, so. I'm
Okay,
hoping between the two of us, we got it right.
fingers crossed.
Fingers crossed, Judge.
I do have it now.
Okay.
To the clerks. Thank you.
Yes, Judge.
Oh, Robert's already taken care of it.
Okay, thank you.
Judge, I know he's not been sworn in, and for the court's information, he's going to be pleading to 16 days on both cases with credit for 16 days.
All right. Okay, I'm going to send you to breakout room number 1, and the clerks will swear you in there. All right, they say they're just printing off the paperwork and we will be ready to start. Lewis is the 2017 CR 6113. That's going to be taken in consideration or no?
No, Judge, the plan is to go ahead and plead true to the MTR
Mhm.
and then to plead also no contest to the 2022 waiver case.
Okay,
Mr. Cervantes has 16 days credit at least on both cases. And so we'll be asking the court to sentence him to 16 days on both.
all right. Marcus Sanders, are you there?
Yes, Judge.
All right, let me spotlight you. All right, we'll start first with the motion to revoke, since that is the quickest one. Court is calling 2017 CR 6113, State of Texas versus Jose Cervantes. Can I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Luis Martinez on behalf of Josue Cervantes.
And are you Mr. Cervantes?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objection from the state?
Objection.
Any objection from the defense?
No, Your Honor.
Mr. Cervantes, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Josue Cervantes Jr. who's placed on deferred adjudication in 2017 CR 6113 for the offense of unauthorized use of a vehicle on December 21st, 2017 for a period of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Judge. Sorry, I lost the motion.
Oh, no problem.
Okay. From the amended motion, condition number 1, on or about the 18th day of January 2021 in Bexar County, Texas, the defendant Josue Cervantes Jr. committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the
State.
others.
Any objections to the state's waivers?
None, Judge.
Mr. Cervantes, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Judge, we're asking that you grant the motion, adjudicate and revoke, and sentence him under 1244 to 127 days. He has 127 days credit, so we're asking that it be a time served judgment satisfied.
Is that the agreement, defense?
Judge, that's our agreement.
Mr. Cervantes, are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
No, ma'am.
Yes.
I mean, yes, ma'am.
All right. Then the court will follow your agreement. The court will grant the motion, find you guilty, not grant you community supervision, sentence you to 127 days in the Bexar County Jail under 1244 of the Penal Code, give you credit for any time served, and the court will show that the judgment is satisfied. Next, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over the definition of weapons or ammunition, you need to contact an attorney for that definition. Do you understand?
Yes, ma'am.
All right, with that, we'll close the case on that cause number. Next, we're proceeding on 2020 CR 0138W. Can I have the parties again announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Luis Martinez.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Cervantes, I'm showing you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor, I have, and yes, I did.
Court will find that the state is in compliance with discovery. Mr. Cervantes, I'm going to show you a document entitled Waiver of Indictment, Reading of Information, and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand that your attorney has certain rights, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were waiving those rights?
Yes, ma'am.
And did you intend to waive those rights and enter into a plea bargain agreement in this case?
Do you intend to waive those rights and enter this plea bargain?
Yeah. Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Next, I'm showing you the document entitled Information. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
Yes, we do, Judge.
State, are you proceeding on the information as presented?
I believe so, Judge. Are we alleging it as a misdemeanor assault?
Yes, it's the court's understanding, and if I'm incorrect, please let me know, that this was an assault choking, but the state is reducing it to a Class A misdemeanor assault, bodily injury, marriage, cohabitation. Is that correct, defense and state?
That's correct, Judge. That's our intent.
Yes, Judge.
All right, so we're proceeding on this as a Class A misdemeanor. Mr. Cervantes, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it? In all the
Yes, ma'am.
appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on this offense as a Class A misdemeanor of assault, bodily injury, marriage, cohabitation? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, he did.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I believe he was.
Mr. Cervantes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review this page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 16 days in the Bexar County Jail. There are no applications. There's to be credit for time served. There's an affirmative finding of family violence. There's to be no contact with Jeanette, Janette, Mendiola, Mendiola. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Judge, it is.
State, is that the plea bargain agreement?
Yes, Judge.
And state, is the complainant aware of the plea bargain agreement?
Judge, my understanding was that the complainant has been uncooperative with their office, but there has been contact with her.
All right, next I'm going to show you the paragraph entitled waiver repeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Then to the offenses charged, assault, bodily injury, merit, or cohabitation, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
Yes, the state offers State's Exhibit 1 and its attachments.
Any objections?
No objection to that, Judge.
Mr. Cervantes, I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Counsel Martinez, I see that the attorney listed is Robert Price.
Judge, that's my law partner. For some reason, the system has him on there, but it's at the very least, it's the same law firm, and I'm the attorney of record.
All right, thank you. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations, or will accept into evidence State's Exhibits 1 and attachments, and the court will review the same.
Send that to me. Thanks.
All right, after viewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge. We waive PSI and ask to proceed to sentencing at this time.
All right, anything you wish to say on behalf of your client?
No, Your Honor. We just ask the court to accept the plea bargain.
All right, then, as previously stated, the court is finding you guilty of assault, bodily injury, married or cohabitating. Sentence you to 16 days in the Bexar County Jail. Give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Jeanette Mendiola. Court will show that this judgment is satisfied. Is there anything else from either side with regards to sentencing?
No, Your Honor.
No, Your Honor.
Mr. Cervantes, I'm showing you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you need a definition of what a weapon is or ammunition is, you'll need to speak to that with an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Martinez, do you understand that your relationship with Miss Mendiola is over? Do you understand that?
Yes, ma'am.
Do you all have children together?
No, ma'am.
So there is no reason whatsoever for you to contact her at all. Do you understand?
Yes, ma'am, I do.
If you end up contacting her or going near her again, you're going to end up with more charges. Do you understand?
Yes, ma'am.
All right, with that, we can go off the record. All right, good luck to you, Mr. Cervantes. Do better. Thank you, Mr.
Thank you, ma'am.
Martinez.
Thank you,
You're
Your Honor.
welcome.
Thank you again, Marcus.
All right, I ain't going to stop live stream. We'll come back Wednesday. Brenda, can you believe Wednesday? We're already halfway through the week. Time is moving quickly.
It is.
And we had hail in San Antonio and there was no rain or anything reported.